thousands of dollars lost and years of waiting to receive their assets. That is what falls your beneficiaries if your estate is not properly in line and if not things are properly titled. What is that? We're going to get into that right now. This is the complete guide to estate planning. What should retirees fix before a crisis? That's not to say a crisis is necessarily coming. Some of you may have gotten your stuff in line, but the problem is if everything is not properly together, you are running straight into a freight train and things could be very bad for you or your beneficiaries. So any estate plan, there really are five pieces that need to work together. You've got a will, you got a trust, you got the durable power of attorney, healthcare surrogate and directives, and the beneficiary designations. All of those individually are very important, and not having even one of those could throw your plan into a tailspin. So why is that? What's going to happen? Let's start off with number one. A will is a pretty basic document. Anybody can draw up a will. You can write on a napkin your wishes, sign it. That's a legal will. It's not a very strong document. And because of that, anything that is simply deeded via a will go through is going to potentially cost thousands of dollars and years of time for your beneficiaries to get their assets. This is potentially a very bad situation. So what is probate? The legal definition of probate is it's the act of proving a will. Because a will is so weak, it's not good enough for you to just say, oh, I have this will, and then that's what happens. If someone wants to contest it, wills are extremely easy to contest. All they have to do is go to the court and say, that wasn't accurate. They weren't in a mentally sound place. Oh, they forgot to include me, a whole list of reasons, and the judge could throw it out. In order to actually prove that those are their wishes, it takes time. The average probate lasts a number of months. It's typically 9 to 24 months. It's a long time. And one of the problems with this as well is even if everything is right and it's in order, you're not allowing your beneficiaries the time to grieve. Because while they're going through this painful moment, for a minimum basically of 9 months, they're having to go fight the courts, work with the courts, try to get the assets. I had a situation like this with my grandmother. She did not have a trust. She died very suddenly. This was during the 2007-2008 crisis. So everything was in order. Nobody was fighting the will, but it still took 9 months in order to get the assets transferred over. In that 9 months, what happened? The housing market went down 50% or more. The stock market went down roughly 50%. So with my parents and my aunts and uncles, they had an idea of an inheritance they were getting, which was accurate at the time. And then after it was all said and done, it was about 50% less. All because there was no plan in place. Just because there was no plan in place, we saw a 50% loss in assets and 9 months of heartache. Do you want that for your beneficiaries? I don't think you do. So back to the slide, this probate. So we already talked, it's the act of proving the will. In the state of Florida, it takes 9 to 24 months. That's pretty similar in every state. Common pitfalls. Probate's not free. They're going to take 3 to 5% of your entire estate's value. Your estate's worth $1 million. They're going to take at least $30K of that. Does that sound fun? Also, if you're a private person, unless you want all your records and your assets to be public, it's important to avoid probate because once it goes through probate, anybody can look up, anybody can research, oh, what did this person have in their estate? Oh, how much did this person inherit? Oh, this person inherited $500,000. That's nice. It's public record. And the other aspect, the last aspect, is a loss of control. In the element where the will's not being contested and all the siblings are working together, that's the Goldilocks scenario. But if there are fights, that's where things become an issue. Because then it's not your beneficiaries or even you who get to decide where your assets go. It is a judge who's never met you in your life. They don't know your life story. They don't know your wishes. They just decide on a whim, okay, Johnny's getting the house. Mary's getting this bank account and that's how it's going to be settled. Johnny's getting this necklace even though Mary wanted it. See how that could be a problem? All because you didn't have a plan in place. Now, we go back to this first slide here. Second option, a revocable living trust, that avoids all that. And common to what you may hear or maybe what some attorneys have told you, Revocable living trusts, they're pretty simple to set up and they should be pretty inexpensive. That doesn't mean that some attorneys out there won't try to charge you 10 grand for a trust, because they will. But you can, in most areas, you can get a simple revocable living trust done for about $2,000. I'm not an attorney. I'm not here to sell you a trust. What I am saying though is they're pretty simple, they're pretty inexpensive, and by having a trust, anything in that trust completely avoids probate. So you avoid the time delays. You avoid the 3 to 5% fee, and you keep control of who is getting the assets. And that's one of the top mistakes, like I said, people in my family have made. Top mistakes I've seen out there is they think, I don't need a trust, I got a will, I'm fine. Just that little decision has the potential to cause an immense amount of heartache. And we want to avoid that at all costs. One of the other ones on here for estate planning mistakes, outdated beneficiaries on your accounts, your insurance policies, your retirement plans. So avoid probate. As long as that beneficiary is alive, and as long as that beneficiary is not simply your estate. If the beneficiary is your estate, it's going through probate. Outdated beneficiaries can be a very big problem, because here's why. Let's say you were married and you have your spouse on there on the account. You don't list any contingent beneficiaries on there. You have your spouse on there. Unfortunately died quickly before you, and you had no time to change it. Now, there's no beneficiaries on the account. So guess what? That IRA is going through probate. Or maybe your spouse is still alive, but they're your former spouse, and you just never really got around to changing it. You don't really pay attention to those accounts anyway. Guess what? Now your former spouse is inheriting that account. One of the top mistakes we see is people who just aren't on top of these things. They're not paying attention to their beneficiaries. They're not paying attention to their accounts. That leads some money that you had maybe mentally earmarked for someone else to go to someone maybe you didn't want it to. The other aspect are your assets not coordinated with your overall estate plan structure. So maybe your assets have one person as a beneficiary, but in your estate, in your trust, in your wills, you say, I want XYZ to get this money. Or maybe you have a trust, but you've got brokerage accounts that are not in the trust name and that don't have a beneficiary, which in that case, guess what? Those assets are going through probate. You set up the initial steps, but you didn't coordinate them enough. So now, even though you have a trust, that money's going through probate. Easy fix was, if you already have a trust, have that brokerage account simply just be in trust name. No other changes necessary, no other extra fees or taxes or anything of that sort. It's a simple fix, but so many people make this mistake. Last aspect is unfortunate. It's waiting until a family emergency to review everything. What happens if you are the family emergency? What if you getting into an accident or you passing away is the family emergency and you just never reviewed it? You waited until the last second, I got plenty of time. And then something happens and now your situation's all a mess and it's left to your beneficiaries to pick up the pieces and deal with it. Do we want that? I think it's pretty selfish, but that's a major problem and it's a major issue we see. Not every situation calls for a trust. In the state of Florida, if you have a house, your house you don't necessarily need a trust for. It's a primary residence. You can get a ladybird deed. Everything basically stays the same. You can just put your beneficiaries on the deed so that when you pass away, they just get the house, but it's not as expensive as a trust. It's very simple. Nothing else has to change. If you have IRAs, it goes directly to your beneficiaries, skips probate. You don't need a trust. However, when it does fit, the benefits are immense. You're wiping away 3 to 5% of those probate fees. You have a trust and everything's titled correctly. Guess what? You don't pay those probate fees. Now, if you have a sizable amount of assets, that could be a sizable amount of money. That might be little Johnny's college fund wiped away because you had $2 million. You had earmarked $100,000 for little Johnny's college fund. And now guess what? Little Johnny's college fund is now the U.S. government's probate fund, or the state of Florida's probate fund. You want that? Who would you rather have the money? Little Johnny or the government? So basically, quick checklist. I'm not going to drone too much on here. Start here. Check your beneficiaries. Check your IRAs, your 401ks. Make sure they're the beneficiaries that you want. Review your powers of attorney, your healthcare documents. Make sure that you have them so that if something does happen to you or you're incapacitated, you have someone you trust who is assigned to make decisions on your behalf. Make sure your titling still matches the current plan, that if you have a trust and you have a non-qualified account, make sure that brokerage account is in trust name. And just make sure to review everything, go over your plan, make sure you have a plan, first of all. Make sure everything is in place, make sure you're comfortable with your assets so that there's something there for when you pass away, because if you don't have the right asset plan, this estate thing may be irrelevant, because if your assets aren't worth anything, then what does it matter? So that's going to be it for today. If you do have any questions or concerns, comment down below. Click the link in the description if you'd like a complimentary consultation call where we'd go over your estate and best ways to potentially set it up. I'm Tyler Nawai. Have a great rest of your day. Bye.